A lot of people have asked me over these years, should a person tell their criminal lawyer the truth? That's a very important question, and I think it needs to be broken down into two things. Let's take the example of a person who's not just presumed innocent, but is actually innocent. He didn't do the crime. If he or she retains a criminal lawyer, there's no question they need to tell the lawyer the full story about what actually happened, because they are in fact innocent, not just presumed to be innocent. The more vexing question is if a person's guilty, say of murder or sexual assault or domestic assault, and they hire me, for example, or any other criminal lawyer, should they tell the lawyer the truth? Well, that's a very difficult answer, but that I'm going to give a difficult, vexing question, and it presents a lot of dilemmas for lawyers in Canada on this issue. And I'm going to tell you the approach I take as well to these particular cases. So let's assume the person's guilty, and should they tell him? So here's a fundamental things. First of all, whatever you tell your lawyer, it's solicitor-client privilege. So you can admit anything to your lawyer, really, that you committed a past crime, for example, and you committed this particular crime, and they can't share that with anyone. So that's between you and the lawyer. They're bound by ethics under the Law Society and the rules of court. That's solicitor-client privilege. Here's the problem. If you're charged with, say, sexual assault or domestic assault, for example, and you tell your lawyer that you did it, that truly and really restricts their ability to defend you. Because now they're not allowed to put you on the witness stand. They're not allowed to say to the judge that you didn't do it. They can still test the Crown's case. They can cross-examine the complainant and try and create inconsistencies and improbabilities and things like that. But they can't suggest to the witness that you didn't do it. It limits their submissions to the court. The judge is going to know, because you're so limited in your cross. So it's a very difficult situation. The practice I do, if a client retains me in this situation and they ultimately admit their guilt and they still want to have a trial, I tell them, look, it's better for you to get outside counsel because you've restricted me. I'm going to have a very difficult time creating reasonable doubt now in your case. I can't call you as a witness. I can't suggest you didn't do it. I can just probe and test the Crown's case in a clever manner, create inconsistency or improbability, but it just restricts. That's my practice. If a client tells me the truth, that they're guilty, I say, look, it's best that you retain another lawyer. Unless they want to plead guilty, of course, and then it's my job to negotiate the best possible result. And by the way, that's a big part of criminal defense lawyers. People don't realize this. Like 90% of the work that criminal defense lawyers do on cases is negotiating, resolving plea deals for the best possible sentence for this offense and this offender. I mean, the Crown always wants 1,000,000 years in jail. It's not always right, and the judge makes the decision, but it's my job to present them in the best possible light. So it does restrict the defense. It's not a good situation for me to represent the person that way, nor for the person. So they may get the message with their next lawyer not to say anything, hopefully to them, and they can present the defense. Of course, some people are going to go lie. Let's face facts. I'm not allowed to suborn perjury. If someone comes to me and says they did it, I can't put them on the stand. I can't let them perjure themselves. People have a misguided impression of lawyers. We do have ethics. We're bound by ethics, and this is a very important rule in society. I know other criminal lawyers, they'll still defend the person when they tell them they did it, but they're not doing their best job. There's no way you can properly represent a person once they've told you you're guilty, because it totally restricts your cross-examination in court due to the rules of ethics we're bound by. And the simple answer is, I think lawyers need to tell that client to find another lawyer, and that the client can work accordingly. They can get the message about what they need to do for the next lawyer. Hopefully, obviously, we don't want them to lie. I never want people to lie, but with the next lawyer, they really probably shouldn't say anything and just let that lawyer properly defend them, not call them as a witness, but now they're not restricted during their cross-examination in any real way, shape, or form. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.